There's nothing in EMTALA that requires an abortion. In fact, you have to consider the unborn life as being a patient as well.
The Supreme Court is gearing up for another abortion battle, this time looking at a case that pits state law against federal law. Idaho versus the United States centers around Idaho's Defense of Life Act, a pro-life law that prevents physicians from performing abortions unless the law says it is necessary to save the life of the mother. The Biden administration alleges that this law conflicts with the Emergency Medical Treatment and Active Labor Act, also known as EMTALA. Congress passed EMTALA in 1986 to require hospitals that participate in Medicare to provide stabilizing treatment to emergency room patients, regardless of their ability to pay.
Congress stepped in and said you can't be dumping patients on other hospitals anymore.
The federal law does not mention specific health conditions or procedures, but does mention that physicians must provide stabilizing care for a pregnant woman and her unborn baby.
At the very least, you must stabilize a patient, and this is important, and the unborn child. So Congress went out of its way to say there are always two patients at interest with a pregnant woman.
In 2022, shortly after the overturning of Roe v. Wade, the Biden administration released new guidance on EMTALA, requiring physicians to perform emergency abortions when necessary to stabilize the mother. The executive order clarifies that when a state law prohibits abortion and does not include an exception for the life of the pregnant person, the state law is preempted. The Biden administration filed its lawsuit against Idaho just months after releasing this guidance. Idaho Attorney General Raul Labrador argues the state's law does not conflict with the federal law whatsoever, emphasizing that the administration's radical interpretation of federal law is nothing more than a reckless disregard for Idaho's right to protect life. U.S. Solicitor General Elizabeth Prelogar says that the state law is narrower than EMTALA, and physicians may not provide the necessary care unless and until the patient's condition deteriorates to the point where an abortion is needed to save her life.
We already have the opportunity to perform an abortion if needed. The reality is an abortion is hardly ever needed to save a woman's life.
Dr. Ingrid Skop is the Vice President and Director of Medical Affairs for the Charlotte Lozier Institute, a pro-life research organization. She's been practicing medicine for more than 30 years and has delivered thousands of babies. She says the addition of abortion in the federal law is unnecessary.
Doctors have been practicing under EMTALA since 1986. We've never been confused about when we might need to intervene for a woman to protect her life in pregnancy.
Roger Severino, the Heritage Foundation's Vice President of Domestic Policy, served as director of the HHS Office for Civil Rights under the Trump administration. He believes the current administration's changes to EMTALA pose serious risks to the conscience rights of pro-life health professionals.
So what is on the table is, can you be forcing hospitals and doctors, including Catholic and other religious hospitals, to perform abortions contrary to state law and contrary to moral and religious convictions of these institutions?
The Supreme Court will hear oral argument on April 24th. This is the second abortion case the Supreme Court is hearing after it returned the issue of abortion back to the states.
We wouldn't be having this discussion if the Biden administration weren't doing everything in its power to twist federal law to impose pro-abortion policies on pro-life states.